All right, we should be back there.
I do not recall that name.
Forensic examiner for the Federal Bureau of Investigation Laboratory.
I don't recognize that name.
How about Bruce McVicker, forensic examiner, Federal Bureau of
Objection,
Investigation?
Your Honor. I'm going to renew my objection. I think this is beyond the scope of determining probable cause. The standards that apply here are that the court weighs the evidence in the light most favorable to the state and avoids credibility and balancing the evidence at this stage. I think we're far into 702 territory at this point.
Mr. Burton.
I'm not sure I understand the objection into 702 territory. 702 deals with reliability of evidence. That's what the court is here to determine. So again, it's directly relevant to reliability. This report criticizes, for the specific samples she's using here, the reliability of this testing. And her response was, oh, but they weren't experts. But the report indicates that there were experts who were consulted on this report. So I think it is relevant, and I think it goes to the issue of reliability, and it's the only question I have on this area as well.
Anything further, Mr. McBride, or do you wish to respond to that?
Just that 702 deals with admissibility. It does discuss reliability, but it's directly related to admissibility of the testimony at trial under the Utah Constitution and under the robust case law in this area. The court does not weigh the evidence, draws the inferences in the favor most in the light most favorable to the state. And I think we're beyond that point now. We're getting into the admissibility questions.
All right. Anything further, Mr. Burt?
No, Your Honor.
All right. Well, as this is the last question, I'm going to overrule the objection, but as a reminder to all parties that this is a probable cause standard, and as it relates to, well, I will just leave it at that.
Are you familiar with that analyst?
No, I'm not.
Okay. Just to close the loop on the PCAS report, what they said in the report was that published evidence supports the foundational validity of probabilistic genotyping with some programs of DNA mixtures of 3 individuals in which the minor contributor constitutes at least 20% of the intact DNA in the mixture, and in which the DNA amount exceeds the minimum required level for the method. Isn't that what they concluded?
That sounds accurate, yes.
And do you know why the level 20% raises reliability issues?
I do not know.
Okay. But you do know that in this case, both your samples had minor contributors below 20%.
That is true, but in this case, it was also only a mixture of 2 individuals.
All right. Now that's the next thing I was going to ask you about, which is what is NOC?
NOC stands for number of contributors.
And when you use this program, this genotyping program, Star Mix, who decides what the number of contributors is?
That's my determination based on my experience and training, looking at the data. That's something I input.
One of the groups that studies your field is the National Institute of Standards and Technology, correct?
That is correct, yes.
They're in the Department of Commerce,
I believe so, yes.
federal agency.
Yes.
And they published a report in 2024 called Forensic DNA Interpretation and Human Factors, Improving Practice Through a Systems Approach. You're familiar with that publication, right?
I am, yes.
And was that publication written by scientists?
I don't recall exactly who the authors of that publication were.
Okay. Just make sure. That the It's a long report, right?
Yes, it is.
And you've read it.
I've read highlights of it.
Is it true that one of the things that they say in that report is they have a section on the complexity of number of contributor estimations?
Objection.
Are you,
Same objection, Your Honor. This is beyond the scope of a preliminary hearing. Again, we're talking about expert reports. We're talking about scientific studies. These materials are all fine to consider at a 702 admissibility hearing. At this stage, where, again, the evidence is viewed in the light most favorable to the state, this is unhelpful to the court's determination and therefore irrelevant to this proceeding.
Thank you, Mr. McBride. Mr. Burt.
Your Honor, I think the report that the state put into evidence, as clarified by this witness, indicates that she reached the conclusion that Mr. Robinson and Mr. Twiggs were, quote, possible contributors to these two samples. And so the one thing the court has to weigh is what is the weight of that opinion given the science or lack thereof? And one of the important issues here is how she derived these statistical numbers. And as an offer of proof, I'll indicate to the court that the numbers derived from this software program, and that software program is dependent in large part on how many contributors the analyst puts into the input of the software. And the numbers can change if the number of contributors is changed. And in this case, as I'll show through the examination, this examiner originally thought there were 3 contributors. And I will show to the court why she changed her analysis, and will indicate through this publication that there has been criticism of the way in which she determined the number of contributors. So I think it's important for the court to assess whether you've got accurate numbers in front of you. The state put in these astronomical numbers and are asking the court to give weight to them. And I'm asking the court to consider how those numbers were arrived at and whether there are reliability issues with regard to those numbers.
So the concern that I have is, I turn to State v. Ramirez, 2012 UT 59 at paragraph 10. It states, furthermore, the magistrate's role does not encompass an assessment of whether such inference is more plausible than an alternative that cuts in favor of the defense. That is a matter of fact-finding, which is left for the jury at trial. And so when I'm staying in my role as a magistrate, I hear what you're saying, but my concern is based off case law that dictates what I as a magistrate should be doing. If I want to stay in that lane, my fear is as we go down further down this path, which again is not precluding if this were to proceed, if there were a bind over, if there was a trial, that certainly that could be determined. But at this point, at this stage, how do you weigh this issue as I'm weighing State v. Ramirez in deciding whether we're going past the probable cause stage?
Sure, and I think the answer to that is we have to take into account the ruling that you made in this case, which is the law of this case, which is when we objected to the hearsay aspect of these DNA reports and other reports, you ruled that you are the ultimate determiner of the reliability of the hearsay evidence being admitted. And you will recall that our argument was the statute was unconstitutional because it was dictating that you find certain evidence to be reliable without considering whether it was reliable. And your ruling, as I understood it, was no, you retain the ultimate determination of whether the evidence is reliable. And that's not a credibility issue. It's, is this reliable hearsay that the state is offering? And so issues that go to whether these numbers that the state is putting in front of you are reliable, I think go directly to the substance of your ruling, which is that your role here is to determine reliability of evidence. And I'm familiar with a case that the court cites, but I think that has more to do with weighing evidence and making credibility assessments, whereas I'm focused on what the court ruled, which is we have to look at reliability here, and that's my job as a magistrate.
Mr. McBride, any final thoughts?
Yes, under Rule 1102B4, this the Exhibit 31 is considered reliable hearsay. In addition, credibility determinations are not proper for the court to make here for the whole reason that, you know, studies supporting this science, studies opposing this science, testimony from this expert or that expert about what is reliable, what is not, what's more reliable, what's less reliable, factors that affect all those determinations. Those are all very, very complex decisions. There will be probably multiple day hearings dealing with that. And a probable cause determination is just not the place to conduct that kind of thorough, in-depth, and searching analysis. Rather, the case law, the Constitution of Utah that says the only purpose of a preliminary hearing is determining probable cause, the case law, the rules that all say the court does not weigh the evidence at this stage, but leaves that for a finder of fact, the jury, in the end. That all supports cutting this line of questioning off at this point rather than going on for into greater depth, Your Honor.
All right. So, based off what's been presented before me, I'm going to sustain in part and deny in part the objection made. I'm going to allow this question to be asked, and so that is denying, but sustain in the sense that this would be the last question, and if Mr. Burt would chooses to, may go on to a different subject or a different line of questioning.
Sure. Did that NIST report conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
Can you repeat that?
Yeah. Did the report, the NIST report that you referenced, conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
I think that goes to the DNA evidence. Again, we never truly know the number of contributors in a forensic sample. So, like I mentioned before, you could have DNA mixtures that are made up of 2, 3, 4 individuals. I have training, I have experience, I followed standard operating procedures. So I'm making the best determination based on the evidence, the DNA evidence that I have, as far as number of contributors goes.
Now, if I could, I'd like to return to your case notes. And could you display for the witness page 365 of tab number 4? And while he's doing that, by the way, it's true that if you change the number of contributors, you're going to get different numbers from the software program.
It depends. So actually, each time you run the software, you will get a different number based on the math that the software system does. But there are studies and validations that show we don't expect that math to be greatly different, usually by a factor of 10. Changing the number of contributors, it depends. If you have a major contributor, someone who's made up most of that DNA profile, if I originally interpret something as 3 calculated statistic, if that major contributor is the individual that I'm comparing to, if I change the number of contributors to 2, based on the studies and based on my own experience, it doesn't change the likelihood ratio of that major contributor by much.
But it does change it, correct?
Yes.
And you just said, I think, that even when you put in the same parameters, you don't get the same answer if you run it through STR mix more than once, right?
That is correct. Based on how STAR Mix utilizes math and distributions, you will never get the same answer twice, but it will be no more than a magnitude of 10.
So that test is not reproducible in the sense that you can run it a sample or your assumptions in there 10 times, you could get 10 different answers.
That is true. Again, all within the first time I run star mix, I'm not going to get a likelihood ratio of 10, and the second time get 10 quadrillion. I might get 10 quadrillion the first time, 2 quadrillion the second time, but even if I run it 10 times, I'm still going to get around the same likelihood ratio value.
Now, could you look at tab number 4, your case notes at page 365, if you could bring that up to the witness? Let me know when you have that in front of you. I think you need to scroll up one page. There we go. Can you identify this page from your notes?
Yes, I can. These were notes that my technical reviewer made, and my technical reviewer, they will review all of my DNA evidence. They will draw their own conclusions as far as number of contributors and comparisons, then compare it back to my conclusions.
All right, so this is regarding the 7 sample, correct?
That is correct. That is one of the samples.
And your original assessment was that there were 3 contributors to this sample, right?
That is correct, yes.
And that conclusion was reviewed by a reviewer, correct?
Correct, yes.
She read the same electropherograms, or the name for the output of this technology you use, correct?
She utilized the same electropherogram, which is the chart that the DNA is on.
And does this page in front of you, is that an accurate representation of your case file?
Yes, it is.
By moving to evidence page 365, and that would be Baker 4.
Mr. McBride?
Yeah, I'll object on relevance grounds.
All right, did you want to respond, Mr. Burt?
Your Honor, it's relevant because the witness originally determined that there were 3 contributors, and I'd like her to explain to the court how she reached that conclusion, because I think it does go to the reliability of her testing here.
All right, so as it relates to Baker 4, and this is her personal notes from Ms. Baker as it relates to what I'm assuming is State's Exhibit 31, that these notes were prepared as part of the report in State's Exhibit 31. I will find that it is
Your Honor,
relevant and that it is admitted into evidence. As regards to publication, what is the request?
Your
Mr.
Honor,
Byrd?
if I may clarify, I think the testimony was that this was not her notes. That these were the notes of her technical reviewer, is what I heard.
Please correct me if I misheard that from both sides. I want to make sure.
did.
I want to make sure. Are these Ms. Baker's notes?
Could I clarify that?
Absolutely.
Ms. Baker, these are notes in your case file, correct?
These are notes in my case file, but they're not my notes.
And the way your lab works, you're not the one that does all the different steps in the testing process, correct?
That is correct.
Other analysts have input that then all goes into the case file, which you have access to and rely upon in rendering your opinions.
That is correct, yes.
All right.
And this particular page is a note written by your peer reviewer that you relied upon.
Correct. After I made my interpretations and drew conclusions, my technical reviewer then reviews the data and draws their own conclusions. So this was created after I had already drew my own conclusions.
All right, I'm just trying to put it together here. And so the question I'm trying to get to, counsel, is, was this particular, I recognize it as it being prepared by someone else, but as it relates to State's Exhibit 31, was this relied upon in order for State's Exhibit 31 to be put together as the report? Because I'm trying to determine relevancy as it relates to that? And that's a crucial point I don't have the answer to just yet.
Okay. Let me lay a more adequate foundation. The case file notes are assessed by you at every step of the analysis, correct?
Not necessarily at every step. Before I issue a report, before I write a report, I review all of the case notes. So that will be any communication log entries, any documentation from the laboratory, the biologists that perform the DNA testing. I will review all of that, write a report, and then give that to a technical reviewer. They will draw their own conclusions to determine if they agree with me. If they do, they will sign off, and then my report and my case file will go for an administrative review to make sure that the laboratory number is correct on all the pages, that if there's any crossouts, there's dates and initials and so forth. Those two reviews have to be done before I can actually make it a final report and case file that gets submitted and sent to the field.
And in this case, correct me if I'm wrong, but the sequence was you originally determined in sample 7, that there were 3 contributors. That conclusion got reviewed. Then you ran some further testing, and then you change your conclusion, correct?
That is correct, yes.
And before you change your conclusion, you of course go back and look at what the reviewer said about her review.
We would have a discussion. If I say a number of contributors was 3, he or she notated that it was 2. We had that discussion. She agreed with 3. So for that step of that process, because again, we're piecemealing this. Typically, in a normal case, we will work all of the evidence. I will write a report. For this situation, I had DNA evidence coming to me throughout the day, throughout the night. So I had reviewers at different steps, which is not usual for a case. Usually, I have one reviewer. So in this case, at that particular time, I had a reviewer. Then when I was submitted additional known samples and used those for comparisons, then I did have additional conclusions and additional reviewers.
But you certainly took into account this notation on this page before you changed your conclusion, correct?
I don't know that I would agree that I took into account. We had already had that conversation. And again, once I received additional known samples and additional information from the field, I then did amend my conclusion.
And these notes are kept in the ordinary course of your business?
Yes.
And they're part of the case file that you rely upon in reaching your conclusions?
They are kept with the case file after I draw my conclusions.
So, Your Honor, I think there's a foundation for this. The state has offered all kinds of hearsay here, and certainly this is, there's no question about the reliability of the entries.
All right. Anything further from the parties before I weigh in on, make my ruling on Baker 4?
No.
The court finds that it is relevant, and as it relates to State's Exhibit 31 and Baker 4 is admitted into evidence. In regards to publication, Mr. Burt, what is your request?
That it be published.
All right, in the courtroom.
In both the courtroom and to the cameras.
All right. Any objection, Mr. McBride? All right. Go ahead and publish that to all screens and be captured by the media.
So these notations at the top there, 7-1 male, discuss 3 NOC and OK with 3. Could you translate that for us, what that means?
Sure. So when my technical reviewer took a look at the DNA evidence, she determined that male DNA was present, and she concluded that she would have called it a number of contributor of 2. Mm-hmm. She compared it to my conclusions. I said number of contributor 3. So we had a discussion as to why she thought it was 2, why I thought it was 3. And she said she agreed with me calling it 3 based on her discussion.
Okay. So was that an extended discussion you had with her, or just?
Oh, no, this was a quick discussion, and this is not unusual. We have discussions like this during the technical process quite often.
And the stamp on the bottom, approved by Tara Benson, is that the reviewer
Yes, it is.
talking about? All right, thank you. Now, I want to ask you to look at page 128 of that same exhibit. No. Is this an electropharogram that is a part of your case file?
Yes, it is.
And is this an accurate representation of what's depicted on this page?
I'm sorry, there's nothing on the screen. Am I?
Yeah, 128.
Yes, it is.
I move that into evidence, Your Honor. This would be Baker 4, page 128.
Oh, I thought I already admitted Baker 4. Is this a different? The previous one was Baker 4, as I understood it.
Yeah, Baker 4, page 365.
Oh, okay. So
And
Baker.
and so this is Baker 4, page 128.
Right, so the previous admitted exhibit is Baker 4, 365. The current proposed one is Baker 4, 128.
That's correct.
All right, Mr. McBride.
If I could have just a minute to update my notes on those page numbers.
All right. 365 was the previous one, unless I heard it wrong.
Yes, that's right.
All right, and the current one is 128.
First, I'll note this is the first I'm seeing these as exhibits. Of course, I have this file, but I was unaware that we were going to be these are going to be offered as exhibits. So I'm looking to find them in my file as we go. Second, again, I'm going to object on relevance grounds to the probable cause determination. We're going through the finite details of the analysis here. And once again, I think these are appropriate questions to raise in a 702 hearing, but with the standards that apply at the preliminary hearing that I've already discussed, I think we're beyond the scope of a probable cause determination as we dive into this evidence.
All right, Mr. Burt.
Your Honor, I think this exhibit is particularly important because the court does not yet have in front of it what an electropharogram is and how it's interpreted. And this particular page will illustrate to the court how the analysts interpreted the peaks on this electropharogram to reach the conclusions that she reached, that there were 3 and not 2 contributors. And I think it will assist the court in determining exactly how this comparison process works and what the output looks like, so the court can see exactly how the interpretations are being made.
And is this the dose that were relied upon so I'm viewing today's Exhibit 31 as a summary, and this more of showing the work of how the summary was reached. Am I misunderstanding how this fits in?
This fits into how the analyst originally was of the opinion that there are 3 people here and not 2. And she will go on to explain how she changed the interpretation from 3 to 2. And the point of this is to illustrate to the court that this is a subjective process to a certain extent, and that people can read these things in different ways. And so I think it will help the court understand exactly what's being compared here. You've got peaks on a line, she will say, and just to let the court know in responsive to Mr. McBride's statement that he was unaware that this is going to be an issue, he and I met with this analyst before the preliminary hearing. The analyst pointed this page out to us as being illustrative of why she originally concluded that there were 3 contributors. So this is not something that's being sprung on the state, He was a part of that conversation, and this particular page was identified by the analyst, not by me. So it is important to understand why we went from 3 to 2 and what impact that has on the numbers that the state is offering.
All right. Anything further?
No.
All right. Under Utah Rule of Evidence 1102, B4, it says scientific, laboratory, or forensic reports and records. I find that this is admissible and is admitted into evidence as Baker 4, page 128, and is a request to publish this document.
Okay, you can.
Was that a yes? Oh, okay.
Yes.
All right. So published, I'm assuming to that
Yes.
screen as well. All right.
Correct.
It may be published. Counsel, just as a reminder, as this is a probable cause, I understand and I appreciate you give me a pointer of where it's going, but just as a reminder, as probable cause, it is admitted, and you may discuss it, but I definitely want to keep this within the track of probable cause.
Understood.
All right.
Thank
you, Mr. Burt.
Okay. Is it true what I just told the court, that you pointed this particular page out as illustrating why you originally thought we had 3 contributors?
Yes, that is true.
So explain to the court, is this an electropharogram?
Yes, this is an electropharogram. Each of those rectangles at the top, for example, D2S441, that is that small segment of DNA that I referred to earlier. And each of those peaks has a corresponding number that is the allele, so that corresponds to the number of repeats that an individual inherited.
And this is what you ultimately, after you get this electropharogram not through running it through STR-Mix. There's a different device that you use to produce these electropharograms, right?
Correct, yes. During the DNA process, this is the last step of that process. So what it's doing is DNA is found in cells of our body. We're taking those cells, we're breaking them open with chemicals to release the DNA from those cells. We're making photocopies of those pieces of DNA so that we can essentially see them. And then the last step is to separate those pieces by size, and the ultimate output is this electropharogram.
Okay. And is it true that you set the parameters for what the machine will pop up in terms of numbering the alleles?
Personally, I do not set that up. That was done during our validation of the chemicals and the software and the instrument that we utilize. There are parameters. So the output of the DNA lets me know, for example, the different types of alleles, but that's not a parameter I set.
I want to make sure you answered that. You set, or your lab sets, what the machine does in terms of labeling particular alleles, correct?
Yes, that's part of the whole process in the validation, yes.
So you could tell the machine, give me all the peaks at whatever level and label them as whatever the alleles are.
I see. So yes, so during our validation, we determine our thresholds, our analytical threshold, and that stochastic threshold that I mentioned before. The analytical threshold is a threshold that was determined during validation that we input into the software that I utilize that says, for example, our analytical threshold is 150. Any peak that is 150 or greater, the software system will give me that allele call or that number for that peak. Any peak that's below the 150, the software system will not give me an allele call for it.
Even though it might be a true allele.
Correct, yes.
So you could say, and you referred to a measurement, you refer to that as RFUs, right?
Yes, that is the unit.
What does that mean?
It stands for relative fluorescent unit.
So in your lab, you tell the machine only label peaks that come above 150 RFU.
The software that utilizes the information from the machine, yes.
However, it's true, is it not, that in determining the number of contributors, you look below that 150 RFU level.
And that is true, yes.
All right, now on this is only showing 4 different locations, right?
Correct, yes.
And you see a number of peaks at each one of these locations. Some of them are labeled, some of them are not.
Correct, yes.
So tell us how you originally looked at this and said there's not 2 contributors, there's 3.
Sure. So first what I do is I count how many labels that I see, so how many of those little squares under each of those locations. So for example, at D2S441, there are 3 squares. Knowing that one piece of information comes from mom and one comes from dad, if it's a single source profile from one individual, I expect to see no more than 2 squares. Because I see 3, that gives me an indication that there's at least 2 individuals. Same thing for the next D19S433 and as well as FGA. There were 3 peaks that were called. So I knew this had to be at least 2 individuals. Then what I do is I take a look at the peaks that are not called and determine could there potentially be a third person included. So for example, at D2, the location farthest to the left, I'm asking myself that 12 in that bottom box, is it the same contributor as, for example, the 22 under FGA all the way to the right? Because I see peaks that are not labeled, it could be that the 12 belongs to one individual and those 2 peaks that are not called belong to a second or third individual. And that at FGA, I could be seeing the 22 from that third person, but that second person has dropped out. Because I'm able to use information below the threshold and I see peaks, that gives me an indication that I can increase my number of contributors to 3, which I did in this case.
Okay, and when did you reach that conclusion, time-wise?
If I recall, it was somewhere around September 12th.
And when did you change your conclusion?
That I would have to refer.
Sure.
I changed my conclusion on September 13th of 2025.
And explain to the court why you changed your conclusion?
I was submitted an elimination sample from Mr. Twiggs, and an elimination sample is a sample in which it's from a known individual, and then there's an expectation that the individual's DNA might be present. In receiving that sample and talking to the investigators, it was decided that Mr. Twiggs should be used as an elimination. When I compared him to this sample, all of the DNA, unlike that major contributor, matched to Mr. Twiggs. So because of that, I determined that there's actually only 2 individuals because those small peaks, there was nothing left for a third individual to be compared to.
You use the phrase elimination sample. That's typically used, is it not, in a situation where you're testing a sample that has more than one contributor?
Not necessarily. An elimination is just simply an individual that we're expecting their DNA to be there. So for example, if we have a stolen vehicle, I will request an elimination sample from the known driver of the vehicle so I can subtract out their DNA to see what I have left over. It doesn't necessarily have to be more than one individual. There certainly has been times where I only detect that known expected individual.
And you said you had a conversation with the investigators as to whether Twiggs should be included as, or you talked to them about whether you should get elimination samples?
I talked to them with regards to if I should utilize Mr. Twiggs as an elimination versus comparing him and offering a statistic.
Okay, but in your report, you concluded, did you not, that one of the contributors to both samples was Twiggs.
That is correct, yes.
Right. You didn't just assume that. You reached the determination that he was the source of both those samples, one of the sources, right?
I don't want to use the word source, but knowing that there was an expectation that his DNA could be present, when I compared him to that DNA sample, I did see his DNA types present. So using the word assumed, that's verbiage that we use when we calculate our statistical calculation. I'm letting the software know, I know this individual is there. I'm assuming that they're there. Based on my comparisons, I did see evidence that that person was there.
But I guess what I'm confused about is we talked before about how your language should never imply an absolute identification. But in the body of your report, you say that one of the contributors is Twiggs. You don't say he's a possible contributor like you do for Mr. Robinson. You say he is a contributor. Do you not?
I do, and with elimination samples, that's slightly different. So, for example, let's say I have a sexual assault case and I have a vaginal swab from a female. She has a consensual partner. I can request an elimination sample from that consensual partner. If I see that they're present, I can say they're present and say the DNA foreign to that victim and that consensual partner is one person, for example. So it's different than comparing a known individual. If they're an elimination sample, I can say that I expect their DNA to be there, and based on my interpretation and reviewing that data, they are present.
And based either on your conversations with the agents or other people, why did you think that Twiggs was someone whose DNA you would expect in those two samples?
So from what I recall, in speaking with the investigators, Mr. Twiggs was a roommate of Mr. Robinson, and it was thought that those items came from potentially Mr. Robinson's home. And I don't recall exactly if it was a situation where a particular towel was known to have been in that house. I don't remember that exactly, but in talking to the investigators, based on their investigation, it was important to assume potentially Mr. Twiggs was present.
Right. Did any investigator ever tell you that the towel did not come from Mr. Robinson's home, but was found in a bush out at the university?
I was aware of that, yes.
So you knew that that towel was not found in a place where you would expect Mr. Twiggs's DNA to be present?
That is correct. It was found outside of a home, but again, based on speaking with the investigators, they had information to suspect that that towel came from Mr. Robinson's home, and I should utilize Mr. Twiggs as an elimination.
Right. And again, you didn't assume that. You actually concluded it based on the match, right?
Based on reviewing Mr. Twiggs' DNA profile to what I developed from these items, I used him as an elimination sample.
Now, you did various STR mix, what I'll call runs, correct?
That is correct, yes.
And the way this works is you input the number of contributors. You determine that. And then they also have something called HD and HP, right?
Correct, yes.
Tell the court what that is.
So those are different propositions. So in calculating the likelihood ratio compares the probabilities of seeing a DNA profile given one of two different scenarios or explanations or hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. So depending on the question being asked is how I set up STAR mix, number of contributors. For example, if I'm utilizing someone as a known elimination sample, I will apply their DNA profile both to the HP and HD.
And the theory of this HP is the prosecution hypothesis, right?
Correct, yes.
And HD is the defense hypothesis.
Correct, yes.
So, and these are things you plug in based on your understanding of what the prosecution and the defense are contending.
Correct, yes.
So how do you plug in the HD in a case where you don't yet have a defense postulating what their theory is.
So HD, or the defense hypothesis, is simply the DNA profile, the probability of the DNA profile, given that it's another unknown, unrelated person to the prosecution's potential person of interest.
Mr. Burt, I don't want to interrupt your line of questions, but we've been going for just shy of 2 hours. Would right now be a good time
It would
to
be a
take
great
15
time, Your Honor.
All right,
Thank
let's
you.
take a 15-minute break. Let's see, we'll come back at 3:50. Court is in a brief recess.
All rise.
You're not sure.
Very, all right.
Very many.
I did not see, but yes, I saw some paperwork
So tell us how he's forcing you to respond to text messages.
because he told me that if I didn't do what he said, he was gonna kill both of my grandmas and leave me alive to suffer and not kill me because he knew that would kill me.
And Ms. Jimenez, when have you shared that particular story with anybody?
I didn't want to have to share any of these stories. I did not want to have to tell people that he had forced himself to have sex with me. That's the only reason why he wanted to continue our marriage or our relationship. I did not want to have to tell anybody. He had threatened to kill my family. I did not want him to say all of this, but I know I have to. I have to because he was getting worse because I was trying to make him stop and he wouldn't stop. He started taking so much. He was going to try to take my job and show my family pictures of me being indecent. Nobody wants that. Nobody wants that.
Do you need a minute, or do you think you can continue?
I can continue.
I mean, Ms. Jimenez, on the last date that Mr. Hernandez was arrested, you were in the car with him, correct?
Yes, that is correct.
You guys were going on base, Lackland Air Force Base, where he has to show ID and go through security guards.
That
Correct?
is correct, yes.
And when they arrested him that day, you left in his vehicle, didn't you?
Yes, I did. He asked me to.
Okay. And not only did you leave in his vehicle, but you had his wallet with you, didn't you?
Yes, I did.
And you proceeded to use his debit cards and his credit cards.
That is correct.
Okay. And so, man, that you're so deathly afraid of, it didn't stop you from taking money out of his accounts.
That is correct.
Now, was I accurate that the divorce between the two of you just got finalized a few months ago?
In March, yes, before the date that you're talking about.
And in fact, you not only did he come into your apartment, but there were occasions where you drove over to his house of your own volition.
I did not have a vehicle. No.
So the only time you drove to his house was when you had his vehicle.
And he picked me up. Yes.
But you see, my point is that you could have told those security guards at the front gate as you're going in that you were being held against your will, or that you were being kidnapped, or anything of the sort.
I only agreed to it because I knew that would happen. I needed help.
And you agree with me that none of these things that you're sharing, a lot of these things you're sharing with the court today do not appear in any police report because you never made those.
No, I never did.
Professor, Mr.
Just a few questions. As far as when Mr. Martinez was talking about using the debit cards and the credit cards after he was arrested, trying to enter Lackland Air Force. I'm sorry, it's Lackland Air Force Base. Can you explain to the court why you used his debit cards or credit cards?
Yes. We had already made plans to go to the bowling alley and to go to the movie theater. And every decision since day one has been decisions that he's made. Never have I once been on his bank account. I have never had a debit card in my name. My both jobs were direct deposited into his bank account. So I never had any money. This was our typical form of me being access to his money, is using his card. I never had anything in my name. No decisions were made of my own choice. It was whatever he said.
Okay, and specifically, you said your divorce was not finalized until March of this year.
Yes.
Around February 19th of 2022 to this year, were your money still being deposited into his accounts?
All of my money had always gone to his account for both of them. The checking account was only his VA compensation, and my money was going to his savings account. We had my checks going into his account, and what we had decided or spoken about, the main reason how he was able to allow me to temporarily trust him was to get this divorce finalized, was that reason for everything to stop. I didn't know how to make it stop.
Okay, but as far as February 19th of 2022 is concerned, at that point you were in divorce proceedings, correct?
Yes.
And so is there a reason you didn't have your money deposited to a separate account to use?
For the accounts, I did set up a chime in my name. It had been just taking maybe 4 paycheck cycles for that change to go over. So we had agreed that he would keep the house because he had nowhere else to go. And I said that was fine. And it had initially started because he had a relationship with another woman. And I had said, okay, I'm going to be the bigger person and let her stay there as long as she pays half of the mortgage. And he said, my lawyer said that I have to financially support you until it is final and over. Whether that's a true statement or not, I'm not sure, but that's what he had informed me of. So that's the only reason why I continued to use his card like I had been before for the whole entire relationship.
Okay.
See, I thought you and Mr. Hernandez worked out the divorce by yourselves, not at the benefit of any lawyers.
He used.
There's no lawyers' names that appear in the divorce.
That is correct.
So if we were to look at the bank statements that we provided to the state, and your deposits going in there and you regularly using those cards, that's one thing.
Yeah, so there's no way for anybody to know whether I swiped it or whether he swiped it, but that's. I had no other access to my funding. There was no card in my name. So I'm not sure how you want me to answer that question, but yes, that's the typical. I didn't have any card to use that was in my name to pay any of the bills or to buy stuff at HEB. So yes, that's how I would pay for things.
Would you agree with me, Ms. Jimenez, that one of the things that you charged on the card when Mr. Hernandez was in jail was a dinner in a restaurant for $100?
No. I went to Burger King. I went to the movies. I had popcorn there. I went to HEB. I went to a Mexican restaurant. I did not have a fancy, extravagant, romantic dinner with another party. No, there's no extravagant restaurant.
So
And others.
Sorry, thank you for coming to testify.
Was Ms. Jimenez being truthful with the court when she says that she had ready access to all your cards at all times? All your credit cards and debit cards?
That is not true.
Okay. Did she routinely, consistently, over the period of time that y'all were together, deposit her paychecks into your accounts?
That is not true.
So the bank statements we provided to the state, are we going to see any deposits from her paychecks?
There are no deposits of her paychecks on any of my bank statements I've provided.
And the last question I asked her about relatively large amount of money being charged at a restaurant while you were in the jail. What specifically was that?
There was one amount over $140 or $150 that was to a Mexican restaurant that I've never even been to. And it was a huge charge. I've never even been there before.
Is your or was your phone number 210-573-9345?
Yes.
Okay. And your email address was speqrdh@gmail.com?
Yes, it is.
Okay. So you'd also agree that not only did you communicate with her via text message, you also communicated with Savannah over emails, right?
Yes.
Okay. And specifically, you sent her numerous emails.
Yes.
Okay. I'm going to show you what's been marked as State's Exhibit number 3. That's that same email address that you said is yours, correct?
Yes.
Okay. And then you email her to call me right now. I'm coming over tonight soon, right?
Yes.
Okay. Why did you email her that?
Because she had wanted me to go over earlier, and then she changed her mind. So I said, why, I was like, why did you change your mind? Call me now. I'm coming over soon.
Oh, so even her changing your mind, you're still going to come over tonight.
Apparently that's what I wrote.
Okay.
Yes.
I'm going to show you what Marcus State's Exhibit number 4. Again, that's that same email address that's yours, right?
Yes.
Okay. And so you emailed Savannah on Sunday, February 13th. Since you don't want to talk to me, that's fine. I will just leave your part blank. You already signed the waiver, so whatever the judge sees that I wrote down is what he's going to go by. Since you don't want to call me or talk to me or make a plan to sign any paperwork because you just get so mad all the time that it's going to cost you in the long run. Thank you for the house. If I sell it, I'll get in contact with you. If not, I'll just let it go to foreclosure and ruin your credit. It don't matter to me anymore, right?
I was talking about the sale of the house because she agreed to that we're going to go and sell it together. And then she didn't want to answer about, we were trying to make a plan on how to sell it and how we're going to divide it and things like that.
Right. But that first line you said, since you don't want to talk to me, right?
About the sale of the house.
Right.
Yeah.
Okay. So clearly she didn't want to talk to you, but you still wanted to communicate with her.
How else were we going to be able to sell the house? I mean,
even though you know that there's that, what I just showed you State's Exhibit
Yes.
number 1, you're not supposed to contact her at all.
yes.
Yes. I'm going to show you what's been marked as State's Exhibit number 5. You can see again, it's all you, D. Hernandez, right? And this is just kind of a snippet. Did you contact her about work, about USA? I'm messaging your work, sending them your pics.
I don't remember saying that, but apparently that's my email. So.
Okay. Somebody else using your email?
No one's. No.
Okay. And then later that day, I'm kind of come over tonight. Previous to that, yes, I'm jealous. Again, we see 1, 2, 3, 4, 5, 6 emails, right?
Yes.
All your same email address, D. Hernandez, right?
Yes.
Okay. Specifically, at 3:54 p.m., Jesus Christ, I'm trying. I do love you. Answer me. Right?
Yes.
Okay. Was she not answering you?
I guess not.
What? Are you calling her?
I don't remember.
Okay.
Maybe his response to him trying to email her.
Okay. With the exception of this top one right here, which is yieldstreet.com, these are all from you.
We were mostly talking about going out to dinner and breakfast and things like that.
So, Mr. Hernandez, you, in response to the state's question, you said, yes, I'm jealous. Is that in response to a question from her asking if you were jealous?
I believe so.
Yeah. So can you think of any other reason why you would have told her that in the way that you did, other than her asking you that question?
Because she told me that she'd already met somebody else and And even though we were still married, just asked if, does that make you jealous because I met somebody else? And I just said something like, yes, I'm jealous.
I do have a question. What is this about sending pics to work? I don't understand that. I think that was a question and it was asked, yes. So what is the sending pics to work about?
I
And
didn't
I don't
have
know if
any,
anyone wants to follow up on that.
Well, I will, Judge. So, Mr. Hernandez, you've heard, not necessarily through this hearing, but before we started this hearing, that she's worried that you might have pictures and or videos of her that she would not want to be shared with other people.
that's correct.
Do you have any such type materials?
No, I do not.
Was there a time in the past where she shared intimate information through either video or phone, or pictures with you?
Yes, there was a time.
Okay. And what did you do with that material?
I deleted them. Any kind of material like that, any kind of material that was revealing or anything like that, I deleted them. I didn't keep any of that stuff.
But my question is, because the state asked him about, I guess, an email or a text message where he said he was sending pics to her work. So I'm just trying to figure out what pics are we talking about? Because he said, yes, I did say that. So what pics are we talking about that are being sent to her work?
I did say that, but there was no pics that I sent. I did say that in the email, but I did not. It was just something that I told her to make her think, I guess, that I was going to send it. But there was nothing I had.
Why?
Just, I guess, angry over the jealousy.
And what pics?
Sorry?
What pics?
I have no pics.
No, I mean, what pics did you want her to think that you had that you were going to see her job?
Some old pics or videos that she had sent me a long time ago before. But I even told her and explained to her that I don't have them. So when I said it again, she should have just, she shouldn't have known, but she didn't send me anything updated or anything. So I'd gotten rid of them, but I guess I wanted her to think that I still had them, but I didn't have them. And I was not going to send anything like that to her employer or employment.
Okay.
And just to make very clear about that, Mr. Hernandez, have you sent those pictures to anybody ever?
No.
So the only person who ever saw what she sent you was yourself.
Correct.
And those items no longer exist.
They no longer exist.
Do you even have the phone or device in which you had them originally with you anymore?
No.
Okay.
And what about the photo on the couch that was brought up?
Judge, that's just a generic photo of somebody watching TV on the couch. There's nothing.
No, I mean, who did that pic get sent to? Because you all questioned.
She testified that was her immediate boyfriend.
Okay. So he sent a photo of himself on the couch with her to the new boyfriend. Is that what I'm to understand?
Well, to show that they weren't necessarily together. In the picture, it doesn't show them together. It just shows that they're both in the same apartment.
Okay. All right. Is there anything else?
I have no other questions.
All right. Any other argument?
Just one last thing for Mr. Hernandez. Mr. Hernandez, you talked about your disability rating from the Veterans Administration, correct?
Yes.
And had you previously provided that information to me in terms of the entire report from the doctor?
Yes.
And in the past, had you applied to the Veterans Treatment Court as part of your legal issues revolving around this particular case?
Yes, I have.
But for some reason, they decided not to accept you, and that's why we stayed in this court.
That's correct.
Okay.
Does anyone wish to speak with regards to that state? I know you're asking for prison.
Yes, Judge. I think it's just based on exactly the testimony you heard from the victim here today, as well as the exhibits that are in front of you. I think that the defendant tries to characterize this as that this is some mutual, consensual back and forth. But I think you can see from just, I know you've been a judge, you've been a defense attorney, but you're also a human being. You can just see from clear from the messages that he's doing whatever he can to get in contact with this woman. And he knows that he's not supposed to, not just from this court's order, but from a protective order. And so clearly probation, whether that's deferred or whether that's straight probation, is not enough of an impediment to prevent him from communicating with the victim in this case. And so prison is really the only next solution. And so there are other steps that we can take to protect this victim if the defendant is in custody with TDC, and ensure that he has no communication with this victim. Further probation is just going to prolong the issue of him continually contacting her, and not just contacting her, but contacting her and harassing him.
Right. So part of the quandary is that I've done a lot of family violence cases before as a defense attorney and as a prosecutor, and I do understand the circle of violence. I understand that. Part of the problem and what I'm wrestling with is the fact that she made contact with him. And I understand the mental issues and reasons behind that. But then I do know the other problem I have, because I know that happens. I do know that I inform everyone when I have a no contact order that the relationship is over. And I don't understand what people don't understand when I say this relationship is over. And I'm sure if I got the court reporter to pull the record, I'm sure I asked you something along the lines of, do you have any children together? And your answer would have been no. And I would have said, well, this is going to be easy. Your relationship is over. You don't have any contact with her. And I'm sure I told you that you should probably not be involved in a relationship. And I'm sure I said not to make light of things, but get an orchid. Did I give you the orchid speech?
I think you did, Connor. Yes.
And the orchid speech didn't do any good.
May I, Judge?
Yes.
I think all of those points have been made and reinforced with Mr. Hernandez many times before we got up here. But if you look at it, during that entire period of time, when he claims they were either reconciling or not trying to reconcile, there's not one incident of violence. He never went to her job. He never caused her any harm over there.
But my concern is he reached out to her and I told him there was to be no contact. I could understand if there's contact because they're in a civil court. I can even understand if there's contact because they're trying to sell a home. I understand those things. Sometimes people are like, but I really need to sell this home and we're trying to finalize our divorce. I understand that. But the contact that he's having with her is outside the bounds of, I'm in civil court, we're trying to finalize this divorce, or I'm trying to sell this home.
We're still with Mr. Burt
We're certainly not.
Ms. Baker, direct examination.
Thank you.
Mr. Burt, your witness.
Ms. Baker, would you take a look at, in your notes, page 24 of 379? Very bottom of the page. Did you write there on the 15th of September 2025, spoke with Special Agent Folger, gave update on report timeline, discussed it upon review, it was decided that additional statistics needed to be run. Report will still be issued with Twigs as an assumed contributor per previous discussions with Folger and Carmack. You see that?
Yes, I do.
And what additional statistics needed to be run at that time?
So at that time, I believe I ran statistics with just Twigs comparing that individual to the sample. If I may refer, I think that was the only additional. Yes, after discussion with my reviewer, it was determined that I was also going to calculate a statistic or compare Twigs by himself, comparing him to the evidence, and having that run in my case file.
Okay. And could you go to tab 38, page 39?
Oh,
Yeah, it should not be on the screen.
let's pull it down from the screen. Thank you. So
Okay.
just to the monitors of the attorneys and the witness, Mr. Burt?
Just for the witness, Your Honor.
Okay, just for the witness.
39. And this is page 39. Is this the DNA report, I'm sorry, the Star Mix report that was produced as a result of your inquiry that involved a comparison of the sample to Mr. Twiggs alone?
Yes, it is.
And is that a 6-page report?
Yes, it is.
And is it a true and accurate copy of the STR mix report for that particular sample?
Yes, it is.
And move that into evidence, Your Honor. This would be Baker 38, page 39 through 44.
Baker 38, page 39 through,
I'm seeking admission as well as publication to the audience and the camera.
I just want to make sure I have the label correct. Baker 38, pages 39 through 44. Did I hear that correctly?
That's correct, Your Honor.
All right. To the state?
Yes, Your Honor, I object on grounds of relevance to the probable cause determination.
All right. And Mr. Burt, would you like to respond?
Submitted, Your Honor.
So I'm not exactly sure what this is in order to
Sure.
determine how it fits into the probable cause analysis.
Sure.
So a little bit more information, because as of right now, I don't have enough to admit it.
Understood, and I apologize to the court. So the report that was admitted into evidence has the conclusion in it that both samples were contributed, that Mr. Twiggs was a contributor to both samples. And this is the report that the analyst ran in order to make that determination, I believe.
All right. Did these reports, were these made prior to State's Exhibit 31 being prepared?
Yes, that's correct.
All right. I will admit, so Baker 38, pages 39 through 44 is admitted and may be published. Again, as a reminder for all attorneys, this is a probable cause standard, so if all parties can just keep that in mind as we're moving forward on this.
Sure,
Thank you.
thank you.
And so it may be published to all screens.
Bates number on this?
Yeah, it's page 39.
No, but the actual Bates number, I'm happy to provide the file and provide this to
So is this the report that you referenced in your notes that you needed to run the sample through StarMix?
Yes.
Now, at the top, this is the StarMix unit dated September 15th, and it relates to item 7-1, correct?
That is correct, yes.
All right. And then down below that, the kit used, if you could go to the summary of the input. You tell the software program, assume there are 2 contributors, right?
Correct, yes.
You input sample 7A,
Correct, yes.
and when you input it, it's just the raw data, right?
Correct, just the numbers from the graph.
The numbers, and then known contributors under HP, the prosecution hypothesis.
Correct, yes.
right? And you put in sample 61, right?
Yes,
That's Twiggs's known sample.
correct, yes.
And then the known contributors under the defense hypothesis, you left that blank.
Correct.
Is that because you didn't know what the defense hypothesis was?
No, again, the defense hypothesis for this situation, if I'm comparing someone, is an unknown, unrelated individual, and that is taken into account during the calculation.
Okay, and then you input that data, and what you get out from that is a likelihood ratio, right?
Correct, yes.
So let's go to page 2 of that report. And is this a summary of the results from that test on the 15th in terms of a likelihood ratio?
Yes, it is.
What is a likelihood ratio? What does that mean?
A likelihood ratio is a statistic that calculates the probability of seeing a DNA profile given one of two different hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. The probability with the higher number gets the support, and the magnitude of the support is determined by the ratio of those two numbers.
That's pretty technical stuff, but the bottom line is that the software computes the numbers, and then you look at those numbers and determine whether it has any significance, right?
I don't know that I would say if it has significance. I report the value that's calculated.
Right, and why is one column, these columns relate to different, what are called population databases, right?
That is correct, yes.
The one on the far left, BAH, is an FBI population database on Bahamans,
And African Americans, yes.
African Americans. Another one for Caucasians,
Correct, yes.
SEH is Southeast Hispanics,
Correct.
and then Southwest Hispanics.
Objection.
That's all I have on that. I'm just trying to explain the chart.
All right, well, there's an objection. Let's pause and turning to Mr. McBride.
Sure.
Your Honor, at this point, I'm going to object on, again, grounds of relevance to probable cause hearing. State v. Drosbeck, State v. Merrill, State v. Ramirez that the court has cited all hold that the court should bind the defendant over for trial unless the evidence is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecution's claim. I don't know that any of this analysis goes to whether or not the expert's testimony and her report is wholly lacking and incapable of reasonable inference to prove her result in this case. We're far beyond this. We're hours into this examination. This feels like a 702 hearing to me. I think we're far beyond a probable cause hearing, Your Honor. I would ask the court to sustain the objection, not allow questioning on this or any other matter that does not deal with the issue of probable cause.
Thank you, Mr. McBride. Mr. Burt.
Your Honor, the state offered this report on a very technical, complex, scientific area of inquiry. And they offered to the court a conclusion in that report that Mr. Robinson and Mr. Twiggs were contributors to two samples that were found at the crime scene. They obviously think that's relevant to the probable cause inquiry, or they wouldn't have offered the report in the first place. So having done that, I think the defense is entitled to inquire whether those conclusions are reliable, because that, again, is the court's ultimate determination here, reliability of this evidence. And the court can decide it's not relevant, it's not reliable, therefore I'm not going to rely on that in determining probable cause. And that, or the court could say it is reliable and it bolsters up other evidence that the court is going to hear from. So the particular report in front of us goes directly to the issue of whether the expert correctly concluded that Twiggs not was a possible contributor, but was a contributor. And the state's theory here apparently is that both Mr. Robinson and Mr. Twiggs are somehow connected to this crime scene. So I think when the court sees what the numbers were generated and how that compares to her own standards for assessment, the court will see that the conclusion is not justified that she reached.
All right. Well, I understand what both parties are saying, and at a probable cause hearing, the issue is whether we walk 1 mile or 100 miles down the path, and so I want to keep it limited to 1 mile, and as opposed to 100 miles, because that would exceed the probable cause standard for a preliminary hearing for what is before me. And so, Mr. Burt, as it relates to the objection, I'm going to sustain it in part. If you want to briefly address this and move on, you certainly may choose to do so, but as it relates to where we're at, my hope is we can keep this very brief as
Yes,
opposed
I
to
can do
going
that.
through all this, so we can move on to whatever else you would like to present.
Thank you. I will do that, Your Honor. And in the interest of doing that, could you bring up on the same screen part of her report, People's Exhibit 31?
And let's take that off.
I'm going to need that up there because I need to do
Oh,
it.
so is it part of the same? Because it was on that screen. I want to make sure that what you're calling up on the screen right now, is it part of this that was already admitted or something else?
It's part of this, which has already been admitted, compared to plaintiff's Exhibit 31, which
I
has
see.
also been
Okay.
admitted.
Okay,
So
thank
they're
you. I
both-
just wanted to clarify.
Sure.
All right. So if you, and do you want that published on this all
Yes.
screens? All right, let's go ahead and do so.
And the chart I would like you to bring up from that report is on page 5. Yeah, and just highlight that. Thank you. So what we've blown up there is from your report, plaintiff's 31, and you provided this chart in the report, correct?
That is correct, yes.
Explain to the court how this works, what this chart is supposed to represent.
Sure. So this is our verbal scale. In addition to the numerical likelihood ratio value that I provide, I also give a qualitative or a verbal equivalent to that numerical value. That gives some kind of context to what that likelihood ratio means.
Okay, and on the left, explain what the greater than 1 million, less than 1 in 100 means. What does that scale relate to?
Sure. So that scale is the numerical value of the likelihood ratio. So if I have a likelihood ratio that's greater than or equal to 1 million, I designate that as very strong support for inclusion. The next example, 10,000 to less than 1 million, I would say that's very strong support for inclusion, and so forth.
So you need to reach a likelihood ratio of 2 in order to get even limited support for an inclusion, correct?
Correct, yes.
Okay. If you could not reduce that. And go to page 2 of the report on the left. So from this chart, when you ran Mr. Twiggs against the sample, what was the likelihood ratio that you determined?
I believe this chart is not the comparison to Mr. Twiggs.
It's not in the report?
The chart at the bottom of the screen is not my comparison to Mr. Twiggs.
Let's verify that if we could. Take that down, the highlight. And repost 38, page 45. I'm sorry. Page 39, that is in evidence. There we go. Second page. Is this the likelihood ratio from your Twigs comparison?
Yes, it is.
Okay. Now, what was the likelihood ratio that you calculated based on this chart?
The likelihood ratio was 1.
1.
Yes.
So that doesn't rise to the level of even limited inclusion, correct?
Correct. It would fall under an uninformative.
Uninformative, and yet you concluded that despite this STR mix reading with a likelihood ratio of 1, that Mr. Twigs was a contributor to both item 7 and item 8, correct?
I did. So actually, I didn't utilize this calculation to determine that Mr. Twigs was a possible contributor, or that I could use him as an assumed contributor. I visually looked at the DNA sample, and the DNA, unlike that major contributor, he also had those peaks. So that was one proposition or one hypothesis that I determined that he was an assumed contributor. There are multiple different ways. We don't have a threshold. I don't have to see 2, 4, 8 peaks to determine I think an individual is present. Given that the field submitted him as an elimination, I assumed he was a contributor. When I compared him to that data, I did see his DNA present. So when I calculated the statistic for Mr. Robinson, I used Mr. Twigs as an elimination.
Let me see if I understand that. The STR mix that you relied upon to include Mr. you relied on the STR mix to include Mr. Robinson as a possible contributor, correct?
Correct, yes.
But when you ran Mr. Twigs's sample through STR mix, the result you got was that he was not a contributor, correct? Or that it was of not even of limited value in including him.
Based on the star mix run, it was uninformative, but I did use my own knowledge and training to determine that I was going to utilize him as an assumed contributor.
Okay. Your own knowledge and training. Is there some standard that you use for deciding when not to rely on the star mix results and when to sort of disregard it and rely on your training and experience?
I can't say that I disregarded it. When I'm comparing someone, that's my first determination. Do I think this person is potentially included or excluded? If I determine that I think they're included, I will run star mix to give weight to that inclusion. Elimination samples are different. If I'm told that an individual is submitted as an elimination sample, I can assume they're there. Visually, I'm able to look at the DNA evidence and determine, yes, I think there's enough evidence there to assume that individual, which is what I did here.
Okay. At D16, Mr. Twigs was a 912, right? According to your electropherograms.
That is correct, yes. Mr. Twigs was a 912 at D16.
912. And did you find 912 at that location in the 8-1 sample?
I'm sorry, the sample 8 or sample 7?
Sample 8.
The only piece of information I had for sample 8 at item D16 was a 12.
And you said Twigs at that was a 912, right?
Correct, yes.
But at that location, the evidence sample was not a 912, but a 12.
That was the only piece of information that was recovered at that location.
Let me ask you about your interpretation rules for excluding someone. Is this an accurate statement? This is from Butler's textbook. In forensic DNA analysis, if any STR locus fails to match when comparing the genotypes between 2 or more samples, then the comparison of profiles between the question and the reference sample is usually declared a non-match, regardless of how many other loci match.
I would agree with that if it's a single source sample. So single source, again, meaning from one individual. If I have a DNA profile from evidence and I compare it to a known individual, if there's a difference at even one location, I can say it's an exclusion. If I have a mixture, it's not that cut and dry. I have to take into account how many people are in that mixture, how many pieces of information I have, is there potential dropout? So it's just because someone may not be present in a mixture doesn't necessarily mean that I'm going to automatically exclude them.
I see. At D19S, what was Mr. Twiggs's type?
It was a 14-16.
Did you find a 16 allele in the 8A sample?
No, I did not.
Okay. At Tho, what was Mr. Twiggs's type?
He was a 7-9.3.
Did you find a 7 allele in the 8-1 sample?
No, I did not. But again, this is a mixture and there is some dropout. So just because I didn't see a 7, for example, does not mean I would automatically exclude someone.
It's a mixture, so there was some dropout. So did you assume that at that location that the allele that dropped out matched his allele?
At that location, no, there's only one individual represented there. So when comparing an elimination, I would essentially ignore that location. I'm looking at the other locations where there was 2 individuals present.
Okay. Now, a couple more topics and then we're done. When you received the evidence, you got more than 7 and 8, correct? You got a number of other samples.
Correct, I did.
You got a backpack, which you labeled as Exhibit 9, and a bunch of items from that backpack, correct?
Correct, yes.
You were initially told that those items related to things that may have been discarded by the suspect.
So initially, we didn't have any information. So we processed that. Those are items that are good for DNA. Not having any information from the investigators, we processed them for DNA. As the investigation continues, it was determined that that backpack was potentially left behind by a bystander, and there was no comparisons needed at that time.
Well, left behind by a bystander, or according to your notes at page 20, the backpack belongs to Kirk's detailees.
Yes, based on the individual that was not my communication log, that was someone else within the laboratory. That was the information that they received.
Before you received any samples, did you request to perform what's called destructive testing on the samples?
Yes, I did. And destructive testing is essentially consuming the sample, cutting the cotton off of the Q-tip or the swab, subjecting it to testing. There's nothing remaining. I have to request permission to consume prior to doing so, and I did in this case.
And why did you do that?
That is part of our protocols, that we have to request permission to consume, and we consume, so DNA, we can't see it, so when an item is swabbed, we don't know how much DNA is on that swab, if anything, or how that swab was used. Did someone just swab using one side of it? Did they roll it and use all sides? Because I don't know that, it's our practice to consume that swab. It's our best chance of getting any DNA evidence.
And that's a determination that you made in this case before you even saw any of the evidence, correct?
Determination to consume?
Yeah.
Yes.
Okay. Now, remember I referred to that NRC report?
Yes.
96. Did they say there a wrongfully accused person's best insurance against the possibility of being falsely incriminated is the opportunity to have the testing repeated? Such an opportunity should be provided whenever possible.
Yes, that does say that.
And does your laboratory have a policy, standard 7.4, which says, where possible, the laboratory shall retain or return a portion of the evidence, sample, or extract?
That is correct. And we do actually return the remaining extract, the liquid from our DNA testing. So we did consume the swab. However, there was a small amount of liquid that was left and returned.
On some of the items, right?
I believe on all of the items.
Well, we'll get to that in a minute. And that policy that I read is from your lab policy, right? The
Yes.
FBI's lab policy.
Yes, it is.
And then is there also a similar policy from the quality assurance standards, the FBI quality assurance standards, which says the laboratory must have a policy on sample consumption. The policy is expected to provide instruction for if and when the laboratory may or may not consume a sample, and any documentation that the laboratory requires.
That is correct, yes.
Okay. Now, your report indicates that certain samples were destroyed, consumed, correct?
That is correct, yes.
And which samples were consumed?
Items 1 through 6, which were swabs from possible smudge, swabs of hand swipe, swabs from possible sweat drop, swabs from possible smudge, swabs of possible smudge, and swabs from possible sweat drop. In addition to items 54 and 55, which were swabs of swiped finger areas and swabs of stairwell railing.
Okay, so when you wrote in your report that those items were consumed, which of those items, and by that you mean the actual swab was consumed?
Correct. So a swab is just like a Q-tip. So the cotton portion of that swab was cut off the wooden stick, placed into a tube, subjected to DNA testing. So we consider that consuming. But again, there is liquid at the end of the process that is returned to the field.
And the normal procedure in terms of sample preservation would be something called sample splitting, right? You split the swab and you use half, you save half so that your testing results can be replicated and retested.
So yes, however, again, I don't know how an item is swabbed. So even if I were to cut that swab in half, it could be that I'm testing the half that doesn't have any DNA and the other half may have some DNA, or the swab may have a little bit of DNA on one side and a lot on the other side. So for the best possible chance of getting a DNA profile, it is our practice to consume the entire swab.
So for the first 6 items, those were swabs that were taken from the northeast corner of the Losi building, correct?
Correct, yes.
And you used all of the swabs, and you concluded that there was no DNA present on any of those items, correct?
That is correct.
So you couldn't do any comparative testing.
Correct. There was nothing for me to compare to.
Okay, and what did you have left after you did that in terms of the volume of extract? What was left?
So it was approximately 3 microliters, so a very small portion.
Very small portion, and you actually used 10 microliters to do your testing of those samples, right?
That is correct, yes.
So if you didn't get any results with 10, what you left over would not be sufficient to get any sort of independent testing done, correct?
It could be tested. However, my expectation, if I took 10 microliters and did not get any DNA, the remaining 3 would also still not give me any DNA.
Okay. And for item 55, that was 2 swabs of a stairwell, from a stairwell railing where the suspect touched the railing, right?
As far as I know, they were swabs from a stairwell.
And correct me if I'm wrong, but I understand from your lab notes that you took those 2 swabs and combined them into one sample and then used the whole sample, right?
That is correct, yes.
Okay. Before you did that, did you inquire whether the 2 swabs came from 2 different areas? For instance, maybe the suspect touched it here, but the other sample was taken somewhere else?
I did not. They were both labeled as coming from the same stairwell, and they were packaged together. So our policies and procedures is that we can combine those two together.
And when you do that, you create a mixture, right?
I don't know that I would agree that combining the two would create a mixture. Given the item of evidence, a stairwell railing, I don't necessarily expect that one swab would have one person, the second swab would have a different second person, and combining the two of them creates a mixture. However, I don't know that for certain, but again, I don't know is DNA present, so our procedure is to combine and consume those swabs.
Okay, and in this case, when you did that, what you got was a complex mixture, right?
I did. I got DNA from more than 5 individuals, so I could not provide a conclusion.
All right. Now,
Mr. Burt, and we're at the 4:30 point. I just want to inquire, without
I just
applying
have
pressure,
one
just trying to
area left.
understand. Okay.
no, be done with her. We talked earlier about your testing of the length of the DNA sequence, the length of the DNA boxcars, not the sequence of A, C, T, and G within those sequences, within those boxcars, right?
Correct, yes.
And is it true that there are different alleles that have the same length when you measure by STRs but have different sequences?
Yes, that is possible.
And I'd like to show you a chart that you have reviewed, I believe. This is, could you bring up 34? This is not in front of the, on the public screen, just for the witness.
Okay.
And is this a chart that you reviewed, that I prepared to, and you looked at to see if I had correctly stated what alleles were found?
Yes, it is.
And does it, as it's presently existing, accurately state what the alleles are at each location?
Yes.
Okay. I would move that into evidence. It's 5 pages and it's Baker 34.
Mr. McBride?
Yes, I object. Unless this exhibit is reasonably likely to defeat the prima facie showing of probable cause, this is irrelevant to the preliminary hearing.
Mr. Burt?
Your Honor, this exhibit and the next one go directly to whether the comparisons being made between Mr. Robinson's sample and the evidence samples are usable and reliable to make a determination that he is a probable contributor.
I'm not sure I'm following with what you're saying on there, right? And maybe it's just because it's late in the day. Could you
Yeah, it could
repeat
be.
that?
So this chart illustrates what allele she found at each location for Mr. Twiggs and Mr. Robinson, and for the evidence samples, the 71A and 81A. The other alleles are on here as well, but we're going to focus on 71 and 81. And for instance, Your Honor, at the, you'll see that under the first reading there is for Tyler Robinson at the D3 location. He is a 17. Okay. And take that down. And then if you go down to the 7-1 towel sample, which is what the topic is of this report introduced by the state, you'll see that she found a 17 there as well, measured only by the length of the DNA strand. And what she's going to testify to is at this location and 5 or 6 others, there are alleles, all of which measure here 17, but actually contain different sequences, and that her testing that she used does not measure for those differences.
And so as it relates to probable cause, that's what I want to keep coming back
Sure.
to. Again, if this was a trial, this may be a little bit different analysis that the trial judge applies. But as a magistrate, taking a look at this and looking at the probable cause standard, how does this comport?
So it comports because it goes to the ultimate opinion expressed in the report that the state is offering, that the report offers reliable support that Mr. Robinson is a possible contributor. And we're asking the court to consider that the comparisons are only based on a limited number of length-based comparisons, and that there are sequence differences so that she cannot distinguish, and I believe she'll testify, she cannot distinguish based on the testing that she did in at least 5 separate locations whether the evidence sample and Mr. Robinson's sample, or for that matter, Mr. Twig's sample, matches the sequence differences here. And this is my final area, and I think I can do it very efficiently, and I think it is important for the court to consider, especially as it relates to the comparison to Mr. Robinson.
Mr. McBride.
And she is also going to testify that the analysis she does is based on looking at the totality and all of the different markers that match and are consistent, and that's how she comes to the opinion that she does. The point is, there are explanations that are susceptible to different interpretations and arguments. Ultimately, we're going to have an expert hearing where all of the literature is going to be before the court, and the court's going to determine if it meets a threshold of reliability for admission at trial. But at this stage, even granting that there may be some argument that may come from defense counsel's position, the court can't weigh it. This does not go to the probable cause determination, and I don't think it's relevant. And this exhibit in particular is not relevant without the testimony of the witness, and so the exhibit should not be admitted on its face either.
But that's why I was trying to lay a foundation that she would, and offered a proof to the court that she would testify that in fact there are these sequence differences at the 5 or 6 locations, 6 different locations relevant to the comparison to Mr. Robinson. And when the state says the court cannot weigh it, the court can weigh reliability. The court has ruled that. So we're simply asking the court to take into account the limited nature of these comparisons and the fact that she cannot, based on the testing that she performed, tell the court whether there are differences between at these 5 locations. She can't match Mr. Robinson to the question samples because she didn't do sequence testing. And she'll also testify that the FBI is in the process of implementing this kind of testing.
All right. Thank you to both sides. I'm going to allow the admission of this evidence, but I'm also going to set a limit of a limited number of questions. We are now at 4:40. This is on the cusp of whether it is applicable to the probable cause standard. I want to afford defense its full opportunity, but I still have to rein it in to keeping it to probable cause and not going into a full exploration, because that's not the purpose of a preliminary hearing. So I will admit Baker 34, but Mr. Burt, I'm going to limit you to how much time do you need to address
I just
this?
need about 4 or 5 minutes. I'm going to, the next chart will be the chart with the what are called isoalleles displayed for the court, so the court can see what we're talking about, and that's it.
All right.
I'm just going to have her document that, in fact, I've accurately stated what the alleles are that have sequence differences.
All right. So it is Mr. McBride.
Just on a second matter, which is I need to cross-examine this witness. She's got to leave town today. I would like 20 minutes to cross-examine the witness.
All right. Well, we'll go with the Mr. I'll I accept Mr. Burt's representations the amount of time, and I'm going to talk less because that's consuming more time, and also allow the state the appropriate time for cross-examination given the nature of this witness having to travel. So, Mr. Burt, I'll turn to you. This has been moved into evidence. Do you want it on the screens?
Actually, I don't need it on the screen, just in the interest of efficiency. Pull up the next one, please.
Okay.
I want 35. Take that one down. And is this exhibit the same chart with what are called the isoalleles indicated?
Yes, it is.
And isoalleles is a term used to refer to these alleles that have different sequence but the same length.
Correct, yes.
So across the top there for allele 17 and D3, there is a allele 17A, allele 17B, allele 17C, all with the same length, but different sequences for each of those three.
Correct, yes.
And similarly at VWA, where you say that Mr. Robinson is an 1819 and 1819 in the evidence sample, there's an 18A, a 18B, a 19A, and a 19B.
Correct, yes.
And similarly for the other areas I've indicated there, I've accurately stated what the different sequence alleles are, correct?
Yes.
So I move this exhibit into evidence, Your Honor, and for publication.
Is this Baker 34?
Yes. 30, 35. Baker 35.
Same objection, Your Honor.
All right, I'll admit it into evidence under the previous statement as it relates to Baker 34. It may be published.
And as you look at these 5 areas, you can't distinguish the evidence samples from Mr. Robinson based on the sequence differences, can you?
Correct. I only utilize length differences, STRs in this case. The FBI laboratory does not use sequencing for nuclear DNA testing, nor am I qualified in it.
All right, what is NGS?
NGS stands for Next Generation Sequencing.
And your laboratory is involved in validating next generation sequencing, correct?
We utilize next generation sequencing for mitochondrial DNA, which is a different subset of DNA testing, but not for nuclear DNA testing, which is what we're talking about today.
All right. But the people who market STR mix also market a sequence platform, do they not?
I'm not aware if they do or do not.
Last question, take a look at well, I'll save that for redirect. Thank you.
Thank you.
All right, turning to the state. Mr. McBride.
Oops. Good afternoon.
Good afternoon.
I want to start by asking you what your training and experience is. First of all, do you have any education?
Yes, I do. I have a Bachelor's of Science in Biology from Salisbury University.
And do you, after your bachelor's in biology degree, what did you do for your career and in further education?
Upon graduating from college, I began working at the FBI laboratory as a contractor. I was assigned to the Federal Convicted Offender Program, which was a program under the DNA unit. During that time, I did that for approximately a year and a half. It was my responsibility to open and inventory and barcode DNA collection kits sent in from federal agencies across the United States. I then became a biologist in the DNA casework unit. I did that for approximately 6 years. During that time, I did the actual testing of items of evidence, so swabbing, cutting those swabs, producing the DNA profile. And then in 2015, I accepted a position as a forensic examiner, which I am still today.
I'm sorry, what year was that?
2015.
So 11 years you've been doing more or less the same duties you have now, is that right?
Correct, yes.
I want to ask you about your lab's accreditation. What is accreditation for a laboratory?
Accreditation is a formal recognition that our laboratory is following a very strict set of standards. We're accredited by ANAB, the American National Standards Institute National Accreditation Board. And our accreditation shows that we have to follow standards such as I have to have a certain education background, how we process evidence, how we store evidence. Every 4 years, we're audited to those standards, meaning an outside body will come into our laboratory, look at my training records, look at our standard operating procedures to ensure that we're following those standards.
And you mentioned your training. So what do you have to do as an examiner there, as a scientist there, for your lab to maintain its accreditation?
So for my training program, I had to complete a 2-year training program. During that time, I learned the science behind DNA testing, and I showed that I understood that science by completing oral board examinations and written examinations. I also then had to show that I could relay those scientific results to a jury by completing moot court exercises. And before becoming qualified, I then took something called a competency exam, or it's like a final examination to show that I'm qualified to perform my duties. During that accreditation or that audit process, my training records were reviewed to make sure that I had the proper coursework, the proper college degree, as well as completing successfully that training program.
And do you have to keep up with ongoing education to maintain your, do you have a certification?
I'm not certified. I'm qualified as an examiner.
To maintain your qualification, do you have to have ongoing education?
Yes, on a yearly basis, I have to complete at least 8 hours of continuing education, and this can be done by attending conferences or lectures or reading scientific literature.
Do you also have to undergo proficiency testing?
Yes, and a proficiency test is a test that we receive from an outside vendor. I process that test like I would any other case and submit that those answers to determine if I'm satisfactory or unsatisfactory. This tests not only me to see if I'm still proficient in my qualifications, but it also tests the laboratory process to ensure that we're getting accurate and reliable results.
Now, as you discussed your work in this case, you talked about your work needing to be reviewed by another analyst.
Correct, yes.
And is that true in every single case?
Yes, in every one of our cases, they have to undergo a technical review in addition to an administrative review.
And it sounds like during those technical reviews and administrative reviews, there's discussions between you and other analysts. Is that accurate?
Yes.
And is that an opportunity for training and learning as well?
Yes, absolutely.
And I assume that training and learning goes both directions, that you're learning and you're also helping others understand your thought process, which may train them as well. Is that accurate?
That's true, yes.
The tools you use, are the tools you use validated?
Yes, they are.
And what does that mean to have a tool that you use validated?
So a validation is a thorough testing of a process or procedure. So before we subject any evidence to testing, we ensure that those process and procedures will work within our laboratory. Based on the validation, we create something called standard operating procedures, or SOPs, and these are kind of like cookbooks. It gives us step-by-step instructions on how to do our process and procedures. And then both myself as an examiner as well as the biologists were all trained to those standard operating procedures and tested to those standard operating procedures during proficiency tests.
Now, you've talked about, I think, a couple of the tools you use. One you call StarMix, is that right?
Correct, yes.
And is that tool validated?
Yes, it's validated both developmentally and internally. Developmentally it's validated by the creators of the software. And then we, the FBI laboratory, also tested StarMix to ensure that we could use it within our laboratory and produce accurate and reliable results.
Now, when you say it was developmentally validated, is that in a peer-reviewed study?
Yes, it is.
And is StarMix used, how widely is StarMix used throughout the world?
StarMix is used in approximately 120 laboratories, both domestically and internationally.
I want to go back to some of the questions that you were asked on direct examination. You were asked about an Exhibit 8.4, Baker 8.4, which is the DOJ Ultra, which is the Uniform Language, what does that stand for?
Uniform language for reporting and testimony, I believe.
Okay. It talks about language that you should use and language that you shouldn't use as an examiner and a scientist, correct?
That is correct, yes.
Now, I want to ask you a little bit about what you do when you have a conclusion, like you did in Exhibit 31. Do you know? Let's see. The directive from the Department of Justice limits the adjectives you can use to describe the evidence and the conclusions that you reach. Is that accurate?
Yes, it is.
And the thinking behind that is to submit the statistical number and let others decide, meaning the reader decide how they want to describe that number. Is that accurate?
Yes, it is.
So, for example, if we can look at Exhibit 31, if you don't mind publishing that. Yes, and that's been admitted, so if we can put it on the screen. And Kimberly, if you could scroll to page 3 when that comes up. Thank you. So item 7, sub 1, is the swabbing from the towel from the rifle. We have the number in written form in the second paragraph beneath the heading, and then beneath that you have a table, correct?
That is correct, yes.
And the likelihood ratio gives the number, right? That's the likelihood ratio. And that's stated in sentence form in the paragraph preceding the table, correct?
Correct, yes.
The only language you can use to describe what that number means from the DOJ directive is very strong support for inclusion, correct?
Correct, yes.
And the sentence there that says the DNA results from item 7.1 are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The reader can assign whatever value they want to that, correct?
What do you mean?
Meaning adjective to describe what that means.
Sure, yes.
The adjective you can use is very strong support.
For inclusion, yes.
Okay, for inclusion. All right, if we go to 8.1, if you'll, Kimberly, if you can scroll down just to make that a little bit easier to view. Same question there. The Results are from 8.1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The adjective you're allowed to use is very strong support for inclusion again, correct?
Yes.
Okay, we can take that exhibit down. Thank you. You were asked about formal activity level, and you described this as the lab cannot testify about, or you cannot testify about what action left the DNA on the object. Is that right?
That is correct, yes.
Does that mean that an individual did or did not touch? Oh, let me ask you this. How can DNA get onto an object?
DNA can get on an object via direct contact, so an individual touching an object. It can also end up on an item via body fluids, such as blood, or through transfer. So if I were to touch an object and then that object is given to someone else, my DNA could potentially be on that other individual through the transfer of DNA.
And your lab can't, or you cannot testify as to what precise action left the DNA on the object, correct?
Correct, I cannot.
Okay. Same question about time. You can't testify about the exact time that DNA was left on an object, right?
Correct.
But there are some indicators that may give some information about how long and the conditions under which DNA was placed on an item, like degradation.
Yes, degradation or the condition of the item. So again, if a firearm, for example, is in a river, I would expect with the water rushing over that item, I may or may not be able to detect DNA. Also, if there's an item of evidence that is exposed to the elements, something that's been left behind 10 years ago, I don't necessarily expect to recover DNA, but something that may have been left yesterday, I might be able to detect DNA.
An item that has been left in the dirt or has been rubbed in the dirt, could that affect your ability to recover DNA?
It could, yes.
Could it also affect degradation?
Yes.
Can UV rays affect degradation?
Yes, it can.
Does degradation keep you from doing your work?
No, it does not.
Is degradation normal?
Yes, it is.
Does all DNA degrade?
It does, yes.
I imagine if it's kept in a pristine environment, it would degrade less than if it's kept in, or if it's found in a less, or out in the open. Is that accurate?
Yes.
Okay. You said with regard to the screwdriver, there is some degradation. Did that affect your ability to reach conclusions in this case?
No, it did not.
You said on item 7, the towel, or the swab from the towel, there was slight degradation, not as much as Exhibit 8. Is that accurate?
Yes.
Did that degradation affect your ability to reach a conclusion here?
No, it did not.
You're asked about the PCAST report. You testified that gave guidance on different areas of forensic science. Do you know what year that report was published?
I don't recall the year.
Do you know if it's been within the last 5 years?
No, it is not.
Meaning it's older than that?
Yes.
Do you know if it's been the last 10 years?
I think it was 2016, but I'm not entirely sure. I would say within the last 10 years.
Let me ask you this. Has the science in your area, can I refer to it as probabilistic genotyping?
Probabilistic genotyping is the math in my area, yes.
The science in your area and in your field, has it developed over the last 10 years?
Yes, it has.
And have there been studies that have made suggestions which have been implemented in the field?
Yes.
You testified about Exhibits 7 and 8, that they both had mixtures. Excuse me. Yes, items 7 and 8. In your testing of these items, that they both had mixtures. And you stated, I want to make sure I understood this. You stated, I believe, that the minor contributor was less than 20%, and that it was actually 5%. The ratio was 5% to 95%.
For one of the samples, yes.
Do you remember that?
Yes.
Does that mean the 5% was from twigs, and the 95%, that 95% is assumed from the the Robinson?
When I calculated the statistic, Twiggs's DNA profile aligned with the 5% contributor, and Mr. Robinson's DNA profile aligned better with the 95% contributor.
Okay. Same question with regard to 8. I think you said the ratio was 11% from the minor and 89% from the major. Is that Twiggs being the 11% and Robinson being the 89%?
Yes, Twiggs better aligned with that 11% contributor, and Mr. Robinson better aligned with that 79% contributor.
You're asked about Baker 4, an exhibit that was titled Baker 4 365. Do you remember this exhibit by chance? I don't have a copy of it, so, well, do you have Baker 4 365? Put that up. And item 7 is the towel, right?
Yes.
Item 8 is the screwdriver.
Correct, yes.
Thank you. You know, it's 5 o'clock. I'm going to wrap up. We can go ahead and take that down. I'm sorry. Thank you for helping out with that. In reaching your conclusions, did you follow the protocols of your accredited lab?
Yes, I did.
And based on your training and experience in following those protocols, did you in fact come to the conclusions described in Exhibit 31?
Yes, I did.
Thank you.
Right, Mr. Burt? And how much time are you anticipating? Right.
You referred on cross-examination to your training and experience, right?
Yes.
Do you agree with this statement in the PCAST report? Experience or judgment cannot be used to establish the scientific validity and reliability of a metrological method, such as a forensic feature comparison method. Moreover, a forensic examiner's experience from extensive casework is not informative, because the right answers are not typically known in casework, and thus examiners cannot accurately know how often they erroneously declare matches and cannot readily hone their accuracy by learning from their mistakes in the course of casework. Do you agree with that statement?
I don't. I think experience, they're right in the fact that we never know the true answer. However, my experience means that I've seen a lot of different DNA. I've seen a lot of validation data, so that does help me come to a conclusion.
Do you agree with this statement by that same report? Good professional practices, such as the existence of professional societies, certification programs, accreditation programs, peer-reviewed articles, standardized protocols, proficiency testing, and the code of ethics cannot substitute for actual evidence of scientific validity and reliability.
I don't think I agree with that either. The science has been heavily validated and tested to show that's reliable. Following protocols that are based on validation, again, shows that my results are accurate and reliable, as well as being proficiency tested.
By the way, you said that that report was not authored by experts, but the head of that group was Eric Lander, who is one of the foremost experts in the area of forensic biology, is he not?
That name does not ring a bell. I don't know who that individual is.
You don't know who Eric Lander is?
No, I do not.
Okay. When did you go to school? What years?
2003 to 2007.
You said that STR mix was widely used and then it's been validated. The PCAST report said the problem is it's been validated by the people selling the product, right?
Developmental validation, yes. Internal validation, no. A laboratory that's going to utilize STAR mix has to validate within their own laboratory.
And the PCAST report said that we need validation data not by the people selling the product, but by independent scientists in order to make this reliable, right?
They do, and that's exactly what happened. There was 31 laboratories that came together in response to the PCAST report and gave their validation data on how they internally validated STAR mix.
And then after that information came forward, the PCAST committee reviewed it, and they said PCAST was unpersuaded by those studies. While likelihood ratios are a mathematically sound concept, their application requires making a set of assumptions about DNA profiles that require empirical testing. Errors in the assumptions can lead to errors in the results. To establish validity with a range of parameters, it is thus important to undertake empirical testing with a variety of samples in the relevant range. And they specifically address the studies you're referring to, did they not?
I believe they did, yes.
Yeah. And then lastly, you said that STR mix is widely used, but as I understand your testimony, you didn't use it and rely upon it for your conclusion about twigs, right? The software told you there was no support there for including them, and you ignored it and decided otherwise, correct?
I did not ignore it. Again, given the type of sample, it was an elimination sample. I compared that individual to the DNA profile that I developed and determined that I could conclude that I could utilize him as an elimination sample.
You said your laboratory was accredited, correct?
Yes.
But you're aware that in 2004, the Inspector General did a comprehensive audit of your laboratory and published a report called the FBI DNA Laboratory Report, a review of protocol and practice vulnerabilities, which found a number of errors in the way that your lab does testing, correct?
Objection. The 2004 study is hardly relevant to this proceeding 22 years later.
It's relevant because he's relying on accreditation to somehow say that these results are valid. This lab was accredited when this study was done.
I'll allow this single question. She may respond. So I'm overruling the objection, and then we'll continue to move forward.
You're aware of that study, right?
No, I'm not.
Okay, thank you. That's all I have.
All right. Anything further for this witness?
Yes, I think there's one follow-up needs to be asked. You were asked that, or you testified that you never know the true answer with field work, correct?
Correct, yes.
And that's compared to ground truth studies where you do know the true answer and you can compare the conclusions that analysts draw with the true answer, the ground truth answer that is the basis of the study. Is that right?
Yes, and that is what our validation is.
Your validation actually studies is a ground truth test in essence.
Yes.
Okay, thank you.
Anything further for this witness?
Thank you.
May this witness be excused.
Yes.
All right, thank you, Ms. Baker. You may step down.
Thank you.
All right. Well, does either party need the benefit of the record before we go into recess?
No, Judge.
All right. Having both parties say no, we'll go ahead and be adjourned until tomorrow at 1 p.m. We do not have morning court for this proceeding, and we'll start up at 1 p.m. in the afternoon. Court is in recess.
All right, everybody. I guess we'll see you back tomorrow at. Oh wait, we gotta raid somebody. We'll see you back tomorrow at 1 p.m. Well, 12 p.m. Pacific. Who shall we raid? Let's see. Who's a good Rumble person to raid? We did Mr. Rotella yesterday, didn't we? So we gotta try and do something different today. Poker player. See Rotella's there. A lot of people here. Let's raid these guys. A revolver. Let's raid them. We'll raid these guys. Right. Yeah.
I never heard a job though of where you could just go missing for what was
All right,
it,
guys,
4
have a good
weeks,
day.
and just
See you
nobody
around.
question it. Just hey, it's just a normal
Everybody,
thing, and he
tell
still
Josh
has a
I said
job.
hi over there.
You know,
while we're
with any other
broadcasting.
job that we have here for the average American citizen, you would be fired. You would be gone a long time ago. You know, you don't show up to work. You don't get paid.